The call came at 2 a.m. I was sitting on the edge of a stiff hotel bed in a cramped room in Frankfurt, Germany, still wearing my blazer from the day before. My feet ached. My eyes burned. I had been in Germany for 9 days, trying to close a distribution deal for my small logistics consulting firm, the company I had spent 11 years building from a single client and a beat-up laptop. The trip was supposed to be the biggest win of my career. Instead, a nationwide airline strike had locked me out of every flight home, and I was running out of clean clothes and patience. When my phone lit up, I saw it was Norman Priestley, the attorney who had managed our family trust for the past 6 years. Norman was a careful man. He did not call people at 2 a.m. for small things. I answered on the second ring. "Joan." His voice was tight, like he was choosing every word with a pair of tweezers. "I need you to sit down if you're not already sitting." I was already sitting. "What happened, Norman?" "Your brother Alan has liquidated the entire trust. Every account, every holding, every asset your parents set aside. It's all gone. The transfers were completed 4 days ago." I did not speak for a long moment. The room felt like it was shrinking around me. The trust was not just money. It was the house my father had sold to fund it. It was the savings my mother had protected through her cancer treatments, through her worst days, through everything. It was the retirement plan I had quietly counted on when my consulting firm had rough quarters. It was the last living piece of my parents. "How much?" I finally whispered. "All of it, Joan. Every dollar." I hung up and called Alan immediately. It went straight to voicemail. I sat there in the dark, shaking, with tears sliding down my face, and I thought, how could he? "My name is Joan Whitaker. I am 62 years old, and I was born and raised in a small town outside Richmond, Virginia, the kind of place where everyone knows your grandmother's maiden name and waves at you from their front porch. I am the older of 2 children. My father, Paul Whitaker, ran a modest contracting business. My mother, Ruth, was a schoolteacher who managed every dollar my father earned with the precision of an accountant. They were not wealthy people, but they were careful people. They saved slowly and deliberately, the way people do when they understand that comfort is not guaranteed and that every dollar put aside is a small act of love for the people who come after you. My brother Alan is 3 years younger than me. We grew up in the same house, sat at the same dinner table, and went to the same church every Sunday. But we were never the same kind of person. I was the quiet one, the planner, the one who stayed home to help Mom during her first round of chemotherapy, while Alan was away at a state college studying business, which he never finished. I was the one who sat with Dad on his last hospital visit, holding his hand while Alan kept saying he was on his way. I married a good man named Patrick when I was 30. We had 12 years together before pancreatic cancer took him quickly and without much warning. I was 45 and widowed with a half-built consulting firm and no safety net except the trust my parents had established for both me and Alan. When Mom and Dad passed, Mom first, then Dad 18 months later, the trust became official and equal. Alan was named trustee because he had more time and lived closer to the bank. I agreed because I trusted my brother. That was my first mistake. I spent the rest of that night trying to reach Alan. I called 6 times. Each time it went to voicemail. By the 4th call, I stopped leaving messages. By the 6th, I just sat with the phone in my lap and stared at the water stain on the hotel ceiling. At 7 a.m. Frankfurt time, Brenda answered. Brenda is Alan's wife. They have been married for 14 years. She's the kind of woman who smiles with her teeth but not her eyes, who says of course and absolutely, while meaning the opposite of both. I had always kept a careful politeness with her because she was Alan's choice, and I respected that. But I had never fully trusted her, the way you sometimes sense a loose step in a staircase before you can actually see the crack. "Joan," she said, her voice warm and practiced. "I heard you've been calling." "Where is Alan?" I asked. "I need to talk to him right now." "He's busy, Joan. Things have been handled. You were never really around for any of it anyway. Always off on your little work trips while we managed everything here." I gripped the phone tighter. "Brenda, that money was not Alan's alone to manage. Half of it belongs to me. I need to know where it went." She laughed. It was a short, light laugh, like I had said something a little embarrassing. It's been put to good use. The family needed it more than a bank account did. I told her I wanted documentation. I told her Norman Priestley was already aware. Her tone shifted slightly, but she didn't break. She said she would have Alan call when he had a moment, and disconnected. I booked the next available flight home. 3 layovers, 31 hours of travel, and a cost that made my credit card groan. Then I sat by the window and watched the gray Frankfurt sky and tried to understand what kind of brother does something like this. The drive from the airport to Alan and Brenda's house took 40 minutes. I had not slept more than fragments in 2 days. My luggage was still in the trunk of my car, and I was running entirely on coffee and something cold and hard that had settled in my chest somewhere over the Atlantic. Their new house sat at the end of a cul-de-sac in a development outside Richmond, a large, pale-bricked house with a 3-car garage and stone columns that had no structural purpose. I had never been inside it. They had moved in 8 months ago and never formally invited me. I had heard about it from a mutual friend. The first thing I noticed when I pulled up was the trash bin at the curb. It was stuffed so full the lid would not close. Sticking out from the top were the edges of photograph albums I recognized immediately. The brown leather spines my mother had bought at a craft store in 1987. 20 years of family photos, sitting in a trash bin. I pulled one out. My parents' wedding photo was inside the front cover. I put it carefully in my car and walked to the front door. Alan answered. He looked at me and immediately looked away, which told me everything. He stepped back to let me in without a single word. The house smelled like fresh paint and new carpet. Brenda stood in the kitchen doorway, arms folded, wearing an expression I can only describe as prepared. On the sofa, sipping coffee from a mug that said, "Queen of Everything," sat a woman I recognized, Vivian, Brenda's mother. Vivian had moved in with Alan and Brenda 2 years earlier after her second divorce. She was 68, sharp-tongued, and had never once spoken to me without looking slightly bored. "You always acted like you were better than this family," Vivian said before I had even set down my bag. Alan finally did what made sense. I looked at my brother. "Show me the paperwork." He slid a manila envelope across the kitchen island without making eye contact. I sat at their kitchen island and read every page of that envelope twice. The statements were thorough at least. Whoever had handled the paperwork had been careful enough to document everything, which meant every fraudulent transaction was right there in black ink for me to read. Brenda's luxury SUV, $44,000. A full kitchen renovation with imported countertops, $61,000. A 2-week cruise to the Mediterranean for 3 people, $18,000. Vivian's cosmetic procedures, listed under a clinic I did not recognize, another $22,000. Smaller charges scattered throughout, labeled vaguely as household and family maintenance. My entire half of the trust, gone in less than 60 days. I stood up slowly, put the papers back in the envelope, and tucked it under my arm. "That's mine," Brenda said. "No," I said. "It's evidence." I drove directly to the office of Richard Ellis, the only attorney I trusted in this situation. Richard had handled Patrick's estate when my husband died and had always been straightforward with me in the way that good lawyers are. No false comfort, no unnecessary delay, just facts and a plan. I laid everything on his desk. He read in silence for several minutes. When he finished, he set the pages down, leaned back in his chair, and said, "Joan, this is a clear breach of fiduciary duty. Alan was trustee for both of you equally. He had a legal obligation to protect your share. He cannot liquidate your half and spend it on personal luxuries without your consent. This is not a gray area." I exhaled for what felt like the first time in 4 days. "How hard will this be to fight?" I asked. He looked at me steadily. "It will be a fight," he said. "I won't pretend otherwise. These cases take time and they cost money. But you have documentation and the law is on your side." I told him to start immediately. Alan called me that night. He was not calling to apologize. He was calling because Richard had sent a formal notice of legal action, and Alan had received it and apparently lost his composure entirely. He screamed at me for 4 straight minutes. He called me selfish. He said I was destroying the family over money. He said Mom and Dad would be ashamed of me for bringing lawyers into a family matter. He said Brenda and Vivian had needs I clearly did not understand because I had never been willing to be part of the family anyway. I let him talk. I had set my phone to record the call the moment I heard his voice, legally, in Virginia, with a clear verbal notice at the start that the call was being recorded. I stated my name, the date, and that the call was being recorded for legal purposes. Alan barely paused before continuing his tirade, which told me he either did not care or did not fully understand what that meant. When he finally stopped, I said simply, "Alan, you stole from me. I want what is mine back." That is the entire conversation. He hung up. I sent the recording to Richard that same night. Richard called me the next morning and said he all but confessed to knowing the distribution was unequal. This is very helpful. He filed the formal lawsuit that afternoon. A full accounting action with a claim for damages. Vivian left a voicemail on my home phone that same evening. She called me, a bitter old woman who never had children, so now she wants to ruin everyone else's family. She spoke slowly and deliberately, like she wanted every word to land. I forwarded the voicemail to Richard without listening to it twice. He told me to keep saving everything. Every call, every message, every scrap of paper, he said. All of it. I started a folder on my desktop that night. I labeled it Evidence. The first court hearing was scheduled 6 weeks after Richard filed the lawsuit. I wore my gray blazer, the one I had worn to every important meeting since Patrick died, the one I thought of as my serious blazer. I arrived early and sat in the gallery and watched the room fill up. Alan and Brenda arrived with their attorney, a man named Foster, who had the polished energy of someone who had talked his way out of many difficult rooms. Vivian sat beside Brenda, wearing a dark jacket with a brooch that looked expensive. Foster opened by painting me as the absent sister. He said I had been unavailable for years of family decisions, that I had delegated trust management entirely to Alan, and that my legal action was driven by jealousy rather than genuine harm. He spoke confidently and at length. When Richard responded, he was brief and precise. He presented the trust documents, the distribution statements, and Norman Priestley's records showing I had never signed any consent for liquidation. He asked the court for a full accounting order. The judge, a steady, unimpressed woman named Judge Holloway, ordered Alan to produce complete financial records within 30 days. She did not look charmed by Foster's performance. She looked like someone who had seen this kind of thing before. I walked out of the courthouse with the specific exhaustion of having told the truth in a room where someone else was lying confidently. My savings were shrinking fast. Legal fees, lost billing days, the Frankfurt flight, all of it was adding up. I had taken on 2 small consulting contracts since returning home, but every hour spent on the case was an hour I could not bill. I went home and ate canned tomato soup and cried quietly, the slow, tired kind that happens when the house is finally empty and nobody is watching. I thought about Alan never once looking at me in that courtroom. Then I washed the bowl and opened my laptop. There was still work to do. The financial records arrived on day 28, 2 days before the court deadline, which I suspected was intentional. They were delivered in a box, hundreds of pages, printed in small font, organized in a way designed to be confusing rather than clear. I think Alan's side expected me to be overwhelmed. They did not know that I had spent 11 years running a consulting firm where reading dense financial documents was a basic job requirement. I sat at my kitchen table for 3 evenings in a row, going through every page with a yellow highlighter and a red pen. I made a spreadsheet. I cross-referenced dates and amounts. I found transfers labeled Family Medical that corresponded exactly to the dates of Brenda's kitchen renovation invoices. I found a charitable contribution that matched the date of Vivian's first cosmetic procedure. I found property maintenance charges that aligned with furniture delivery receipts I had seen photographed in Brenda's social media posts. Every lie had a paper trail. Every cover label had a corresponding truth somewhere in the records. Richard used my spreadsheet as the framework for Alan's deposition. When Alan sat down across from Richard and a court reporter in a conference room 3 weeks later, he was not prepared for how specific the questions were. Richard walked through the transfers one by one, amount by amount, date by date. Alan cracked around the third hour. He admitted, quietly and without making eye contact, that Vivian had suggested the liquidation. He said she had told him and Brenda that the trust money was sitting idle and that Joan, meaning me, would just pour it into her company anyway. He said he thought at the time that it was a reasonable way to help the family. He said all of this under oath. Richard came out of that deposition looking like a man who had just found exactly what he was looking for. 2 weeks after Alan's deposition, something unexpected happened. A woman named Carol Fenn reached out to Richard's office. Carol had worked as a loan officer at the branch of the bank where my parents had originally established the trust. She had known my mother, had helped her open the original savings account 30 years ago, had attended Ruth's retirement party, had even sent flowers when Mom passed. Carol had seen the public court filing in the local newspaper. She had sat with it for a few days, she said, before deciding to call. She told Richard that she remembered conversations with my mother during the trust setup. Specific conversations in which Ruth Whitaker had been very clear that the trust was to be split equally, and that neither child could access the other's share without written mutual consent. Carol had written notes. She no longer had them, she said, but she remembered clearly. Her testimony was not yet admissible. Richard told me it needed corroboration to stand on its own. But it mattered. It gave us a direction to look. And it gave us leverage in the negotiation that Alan's side had quietly been trying to start behind the scenes. They offered a settlement, 10 cents on the dollar, a flat payment of roughly $40,000 against the $400,000 that had been spent. I sat with the offer for approximately 30 seconds. Reject it, I told Richard. He nodded like he had expected nothing else. He sent the rejection that afternoon. That evening, Vivian began calling my home phone. 3 calls the first night. She did not leave a voicemail on the first 2. On the third, she cried, genuine-sounding, labored crying, and said that her health was failing and that my lawsuit was killing her slowly, and that my parents would never have wanted this for the family. She called twice more the next night. I saved every message to the folder labeled evidence. Judge Holloway ordered a full forensic accounting. This was not a request. It was a court order, and it meant that a court-appointed accountant, a methodical woman named Audra Sims, would go through every transaction in the trust's history with the kind of attention that no amount of mislabeling could survive. Alan's side responded by doing something Richard had half expected. They tried to hide what was left. The McMansion was transferred quietly into Brenda's name alone. The paperwork was filed with the county recorder 3 days after the forensic accounting was ordered. Richard caught it within 48 hours. He filed an emergency motion to freeze all asset transfers. Judge Holloway granted it the same afternoon, with a note describing the transfer as an attempt to frustrate the court's mandate. I read that phrase 3 times. Foster then filed a motion claiming I had verbally agreed, years before my parents died, to give Alan full control of any future inheritance. He said witnesses could confirm this. He did not name the witnesses. The motion was thin and the argument thinner, but it bought them more time on the calendar. I drove past my parents' old house one Sunday, the house where Alan and I had grown up. A young family lived there now. Toys on the lawn, a bicycle against the steps, the shutters painted blue instead of the dark green my mother had always kept. Her garden was gone, replaced by smooth, uninterrupted grass. I pulled over at the end of the street. I cried for a few minutes. Not about strangers living in the house, that was not a wrong. I cried because I understood what Alan had really taken. Not just money. The evidence that our parents' careful, patient lives had meant something lasting. He had erased the last proof that they had loved us equally. Then I drove home, made coffee, and called Richard. There was always something that came next. 2 months before trial, a man named Walter Crane contacted Richard's office. Walter had been one of my father's closest business partners. They had subcontracted together on construction jobs for almost 15 years, had been in each other's weddings, had spent Sunday afternoons watching football in each other's living rooms. Walter was 71 now and walked with a cane, but his memory was clear and his indignation was precise. Walter had heard about the lawsuit through the same small-town network that carries everything eventually. He called Richard and said he had something relevant. When Richard brought him in for a deposition, Walter produced printed emails. Emails that Alan had sent to a mutual acquaintance 14 months earlier, while our parents were still alive in their final months. In those emails, Alan wrote that he intended to make sure I get my fair share before Joan finds a way to claim the whole thing. He wrote that he had done all the work around here, and that I had been off building her little empire while the rest of us handled real life. He wrote that Vivian had a plan and that it was cleaner than Joan would ever expect. The word plan appeared 3 times in different emails. Walter handed over every printed page without hesitation. Paul Whitaker was a good man, he told Richard simply. His daughter deserves what's hers. Richard added the emails to our evidence file. The following week, Brenda cornered me in the produce section of a grocery store near my house. She stepped close and lowered her voice and said, "You think you're winning. We will drag this out until you can't afford your lawyer anymore, and then you'll have nothing." She smiled when she said it. I smiled back, walked calmly to the customer service desk, and asked if I could speak to the manager about reviewing the store's security footage for the past 20 minutes. The footage went to Richard the next day. The forensic accountant's report was filed with the court on a Tuesday morning. Audra Sims had spent 11 weeks going through every record. Her report was 94 pages long, written in the careful, neutral language of accounting, and it was devastating. She had traced every dollar from the original trust balance to its final destination. She confirmed that my half, the full and equal share my parents had intended, had been spent entirely on personal luxuries, gifts, and lifestyle upgrades, none of which had been authorized by me, and none of which could be legitimately classified as trust management expenses. She also found something Richard had suspected but not yet confirmed. Alan had spent not just my share, but a portion of his own share as well. Money that had been earmarked to offset the trust's administrative costs over time. On a business venture he had started shortly after our parents died. The business had produced no income and no product. It appeared to exist primarily on paper, funded with trust money. Judge Holloway scheduled a trial date for 3 months out. I started sleeping better. Not perfectly. I still woke at 4 sometimes, running through numbers in my head, but better. I felt the slow, solid movement of the case, working the way honest cases are supposed to work, when you have done things correctly. Then, 1 week after the trial date was set, Alan's attorney filed paperwork declaring bankruptcy for the business Alan had created with trust funds. Foster argued this shielded the business assets from any judgment. I called Richard in a panic. He was calm. "Joan," he said, "when a debtor files bankruptcy to avoid a civil judgment, the bankruptcy trustee investigates the debtor's finances. That means everything Alan's been hiding goes under a second set of eyes. He just invited the federal government into his finances." He paused. He made our job easier. Discovery continued through the winter. As Richard and Foster exchanged documents and questions in the formal legal process, a picture emerged that was both clearer and uglier than I had initially understood. The plan to liquidate the trust had not been impulsive. It had been discussed, strategized, and set in motion over a period of approximately 8 months, starting while our mother was still in her final months of life. The recorded conversations we obtained through Discovery included a phone call between Vivian and Brenda from 13 months earlier. In it, Vivian said that Joan, meaning me, had no children, no real family, no reason to hold on to that money, and that letting it sit there for her is just wasteful when we have real needs. Brenda agreed. She said Alan was nervous but that she would work on him. 2 months later, Alan signed the liquidation paperwork. I sat in Richard's conference room and listened to the recordings on a laptop with small external speakers. The voices were tinny through the speakers, but the words were perfectly clear. I felt no panic as I listened, no surge of emotion, just a cold, quiet clarity, the kind that settles into your bones when you finally understand the full shape of what was done to you. Vivian had treated my lack of children as a moral argument for theft. She had looked at my life, my work, my independence, my careful savings, and decided it was worth less because it did not look like hers. I thought about my parents, who had worked and saved and protected their children equally, without conditions or qualifications. I thought about Patrick, who had believed in my firm from its first struggling year. I thought about the photograph albums I had pulled from the trash bin at the curb. I went home that night and slept 8 hours straight for the first time in months. The pretrial conference was held on a cold February morning. I arrived early. I sat in the hallway outside Judge Holloway's courtroom on a wooden bench and drank coffee from a paper cup and watched people move through the courthouse. Lawyers with rolling briefcases, a young woman in scrubs who appeared to be in the wrong building, a janitor pushing a mop bucket slowly down the marble floor, unbothered by all of it. Alan arrived with Foster and 2 paralegals carrying boxes. He looked like a man who had aged considerably since the first hearing. The bright, easy confidence he had always carried, the charm that had gotten him through life on the strength of a good handshake, was no longer visible. He looked at me once, briefly, and then looked away and did not look back. Brenda walked in behind him. The expression she had worn in their kitchen the morning I demanded the paperwork, that prepared, armed expression, was gone. She looked tired. The designer bag on her arm looked out of place with everything else about her. Vivian was not present. Her attorney had submitted a letter citing health concerns. Judge Holloway ran the pretrial conference with her characteristic briskness. She reviewed the evidence summaries from both sides. She addressed 2 outstanding procedural motions from Foster's side, both of which she denied. She warned, clearly and directly, that any further delay tactics or procedurally improper filings would result in sanctions against the filing party. Foster nodded carefully. Alan stared at the table. I walked out of the courthouse into the gray February air feeling lighter than I had felt in any of the previous months. Not triumphant. Trial had not yet happened, and I had learned by then never to confuse momentum with outcome. But lighter. The weight of uncertainty was lifting. The shape of what was coming was becoming clear. 3 weeks before trial, the bank called. Not a customer service line. The branch manager of the bank where my parents had originally set up the trust. Her name was Patricia Owens, and she said her team had found something during a routine audit of inactive safe deposit boxes. My parents had maintained a box at that branch for over 30 years. When they died, the box had been listed in the estate inventory, but its contents had been recorded as personal documents of no financial value, a detail filed and forgotten. Patricia told me the box was still in the vault. It had never been claimed. It still carried my father's name. Richard obtained a court order to open it the following morning. Inside was a sealed envelope addressed to both our children. Inside that envelope was a 2-page letter in my mother's handwriting, dated 4 months before she died. I recognized her writing immediately. The looping, careful cursive she had used for 30 years of lesson plans and birthday cards. Seeing it in that vault, in a letter she had written knowing she was dying, was one of the hardest moments of the entire year. The letter was clear and specific. It stated that the trust was established for Joan and Alan equally and permanently. It stated that neither child could liquidate or access the other's share without both signatures in writing. It stated that any trustee who violated this condition had acted against the family's explicit wishes and against the intentions of both Paul and Ruth Whitaker. My mother had not been a lawyer, but she had been a school teacher, a woman who chose her words deliberately and said exactly what she meant. The letter was dated, witnessed, and notarized. She had thought ahead, the way she always had. Richard read it twice in silence. Then he looked up and said, "This changes the weight of everything." We amended the complaint that afternoon. Richard called it the smoking gun. I called it my mother, still looking out for me. Trial began on a Monday in early March. I had prepared with Richard for 3 full days, reviewing testimony, going through documents, practicing the discipline of staying factual under pressure. He told me, gently but directly, that judges remember witnesses who are calm more than witnesses who are emotional. He was not telling me not to feel things. He was telling me when to show them. I took the stand first. Judge Holloway's courtroom was quiet and still in the way important rooms become quiet when the moment arrives. Alan and Brenda sat at the defendant's table with Foster between them. Walter Crane was in the gallery. Carol Fenn was in the gallery. Norman Priestley sat near the back, hands folded on his briefcase. Vivian's chair was empty. Richard walked me through the entire story. My parents' work, the trust's creation, Patrick's death, my consulting firm, the Frankfurt trip, Norman's call at 2 a.m. I spoke in complete sentences and did not look away from whichever face I was addressing. I described calling Alan 6 times from that Frankfurt hotel room without a single answer. I described reading the spending records at their kitchen island while Vivian sat on the sofa with her coffee. When Richard asked what the trust had meant to me personally, I paused and said, "It meant that my parents trusted me to continue being responsible. It was the last conversation they had with me through their actions. It meant I could keep building the business my father always believed in, without fear of one bad year ending everything." The courtroom went completely silent. I glanced at Alan. His face had gone pale. He was staring at a point just past my shoulder, not at me or the judge or anyone. He looked like a man hearing something no one else could hear. Richard told me afterward that moment shifted the room. I know only that I had said something honest, and honesty has a sound that polished arguments cannot replicate. Brenda took the stand on the second day of trial. Foster had prepared her carefully, and it showed. She answered his questions smoothly, with a tone of patient reasonableness she had clearly practiced. She described the trust management as a burden that fell entirely on Alan while I was away building my career. She framed the expenditures as family needs that had been deferred for years. She spoke about Vivian's health in a way designed to generate sympathy. When Richard rose for cross-examination, he was quiet for a moment. Then he placed the forensic accounting report on the table in front of her, opened to a specific page, and asked her to read aloud the description of the transaction dated 11 months ago. "Luxury vehicle purchase," she read. $44,200. "Was that vehicle purchased for Joan Whitaker's use?" Richard asked. "No," she said. "Was it purchased for trust administrative purposes?" A pause. "No." "Did Joan Whitaker sign any document authorizing that expenditure from her share of the trust?" She looked at Foster. Foster did not move. "No," she said. Richard repeated this process for 7 more transactions. By the 4th, her practiced composure had cracked. By the 7th, she was giving short, flat answers, no longer looking at anyone at the defense table. By the end, she had confirmed under oath that she had known the money came equally from Alan's share and mine, and that she'd known I had not been consulted, had not signed anything, and had not been told. Alan testified briefly and looked exhausted. He contradicted 2 of Foster's opening statements. The kind of contradictions that happen when a person has been managing lies so long, the lies stop aligning. Richard noted them quietly. Vivian testified via video deposition. She tried the frail grandmother approach. Judge Holloway asked sharp questions about the timeline of Vivian's conversations with Brenda. The answers did not match the recorded phone call from Discovery. The judge made a note and did not look moved. Closing arguments came on the 4th day. Richard stood and spoke for 40 minutes. He did not use a dramatic voice or big gestures. He laid out the numbers the way you describe a simple mathematical fact. The trust had held this amount. My share was this amount. These specific transactions had spent this amount of my share. None of them had been authorized by me. And the law required that a trustee who acts this way must make the injured party whole. He referenced the letter from the safe deposit box, quoting the specific language my mother had used, the schoolteacher's language, precise and unmistakable. He referenced Walter Crane's emails. He referenced the deposition in which Alan admitted that Vivian had suggested the liquidation. He referenced Brenda's cross-examination, the 7 transactions she had confirmed under oath. He referenced the asset transfer to Brenda's name alone, caught within 48 hours, frozen by court order, and described it as evidence of consciousness of guilt. He concluded by saying, "Joan Whitaker did not come to this court for revenge. She came for what her parents intended her to have and what the law says she is owed. Nothing more and nothing less." Foster's closing was long and reached for everything that hadn't worked during the trial itself. He questioned my motives and my involvement with the family. He described my consulting trips as evidence of detachment. He tried one more time to paint me as the distant, self-interested sister who had ignored the family for years and now wanted credit for caring. It sounded hollow even to me, and I was the one being described. Judge Holloway said she would issue her ruling in 2 weeks. I drove home that evening on empty roads, the radio off. I thought about my mother's letter sitting in a file folder in Richard's office. I thought about the photograph albums I had pulled from the trash bin. I thought about Patrick, who had believed in me before I believed in myself. I did not know if justice was really coming. But I had done everything the right way, and no one could take that from me. During those 2 weeks, while we waited for the ruling, Alan's side made one final attempt. Foster filed an emergency motion on a Thursday afternoon, just 11 days before the ruling was due. The motion claimed that new evidence had come forward showing that I had secretly borrowed against the trust approximately 8 years ago, before my parents died, in an amount that nearly equaled my claimed share. The motion argued that this borrowing made the entire basis of my lawsuit fraudulent. It was a lie. A specific, detailed, fabricated lie. The kind that is dangerous precisely because it sounds specific and detailed. Richard called me the evening the motion was filed. I could hear in his voice that he was not worried, though I was. "Joan," he said, "if you had ever borrowed against that trust, there would be bank records, loan documents, and your signature on paper somewhere. Can you tell me with complete certainty that no such documents exist?" "Richard," I said, "I never borrowed a single dollar from that trust. My mother would not have allowed it even if I had tried." "I know," he said. "I know because I already pulled your full banking history for the relevant period the week we filed suit. There is no such loan. No record, no signature, nothing. This motion is fiction." He responded to the emergency motion with a 6-page brief and a complete record of my financial history covering the years in question. The brief was methodical, documented, and unanswerable. Judge Holloway heard the motion on an expedited basis 2 days later. She denied it from the bench, without pause, and described it in her verbal ruling as unsupported by evidence and procedurally improper. She added that the filing had all the characteristics of a last-minute delay tactic, and that any similar motions going forward would result in immediate sanctions. It was denied with prejudice. The ruling came on a Thursday morning, 14 days after closing arguments. Richard and I sat together in Judge Holloway's courtroom. Alan, Brenda, and Foster sat at the defense table. Vivian was again absent. The courtroom was fuller than I had expected. A few journalists from local papers, several attorneys from other practices who had apparently been following the case, and a handful of people from the community I had not expected to see. Walter Crane was in the front row of the gallery. Carol Fenn sat 2 seats from him. Norman Priestley was near the back again in the same seat. Judge Holloway entered and took her seat, and did not pause before she began reading. She did not build toward her conclusion. She stated it in the second paragraph. Full breach of fiduciary duty. Alan Whitaker had violated his legal obligation as trustee in the clearest possible terms with documentation, premeditation, and subsequent attempts at concealment. She ordered full restitution of my share. She ordered interest calculated from the date of the first unauthorized transaction, nearly 14 months of interest. She ordered Alan to pay Richard's legal fees in full. She ordered punitive damages, a separate amount intended to penalize conduct the court considered particularly egregious, based on the documented evidence that the liquidation had been planned in advance, concealed through mislabeled transactions, and followed by an attempt to hide assets after the lawsuit was filed. She read all of this in her steady, unhurried voice. The courtroom was very quiet. I heard Brenda make a small, sharp sound. Not a word, just an involuntary release of air. I looked at Alan. He was staring at the table, his hands flat on the surface, completely still. Vivian was not there to react. I sat very still. I did not cry. I did not smile. I just breathed slowly and let the words settle over me the way rain settles, covering everything evenly, without favoritism, reaching every corner. It was over, and it had been done the right way. they could not pay. The total judgment, restitution, interest, fees, and punitive damages, was more than what remained of what they had. The money was gone, spent across 14 months on things that could not be unsold or refunded or returned. The court had always understood this was a possibility. When people steal and spend, the spending does not reverse itself because a judge orders it to. But a judgment without immediate payment is not the end. It is a legal instrument, and Richard knew exactly how to use it. He filed for asset seizure the same week. The McMansion, the pale-bricked house with the stone columns and the 3-car garage, the house that had been transferred into Brenda's name alone in a failed attempt to protect it, was listed for court-ordered sale within 30 days of the ruling. I did not attend the listing appointment or the open houses or the sale itself. I did not need to be there. The court handled it on my behalf, as courts are designed to do. Brenda's luxury SUV was repossessed by the lender, whose outstanding loan was subordinate to the civil judgment. A simpler vehicle was what they drove after that. I heard about the repossession secondhand through someone who had seen it happen. I felt nothing particular about it, just the quiet recognition of a consequence completing itself. Vivian's situation was the one I had not fully considered. With Alan and Brenda's finances gone, the arrangement that had sustained her lifestyle for 2 years collapsed entirely. She could no longer stay. The state-assisted facility she moved into was the kind she had dismissed in earlier conversations, speaking about such places with a particular, casual contempt. I did not feel satisfaction about that. I felt the simpler thing, that choices have weight, and weight finds somewhere to land. Alan and Brenda moved into a rented duplex. The case was closed. The judgment stood on the public record. Alan came my door on a rainy Tuesday evening in late April. He came alone the first time, just him, standing on my porch with his hands in his jacket pockets and rain dripping from his hair. He looked smaller than I had ever seen him. Not physically. He had always been taller than me, but in the way a person looks when something central in them has collapsed. I opened the door, but did not invite him in. He said he wanted to talk. He said things had gotten out of hand. He said Brenda was struggling and that the kids, his stepchildren from Brenda's previous marriage, who had lived in that house, were now sharing a bedroom in the duplex and that it was hard. He said he understood he had made mistakes. He said he was hoping I could help the family get back on its feet. I listened to all of it. When he finished, I said, "Alan, I spent 11 months fighting for what was mine. I did it with lawyers and evidence and court orders because you did not leave me any other option. I did not threaten you. I did not lie. I did not try to hide anything. I just told the truth and let the process work. That is all I ever did." He started to say something else. I said, "You made your choices. I made mine. The right way. I wish you well, and I mean that. But I can't give you what you lost by taking mine." I closed the door. Brenda had been waiting in the car at the end of the driveway. She did not get out. I saw the car sit there for a few minutes in the rain before it drove away. I went back inside and made tea and sat with it until the house was quiet. The final accounting from the court arrived in May. The check was not the full original trust balance. It could not be. Much had been spent irreversibly, and the judgment covered what could be recovered through seized assets and the bankruptcy proceedings, not the full amount that had been taken. But it was substantial, enough to reset something real. Enough to matter in the way my parents had always intended it to matter. I had made a quiet list, months earlier, of what I would do when and if the money came back. I had not written it down anywhere. I had just held it in my head during the harder nights, when the legal fees were climbing and the billing hours were thin, and I was eating soup from a can and wondering if honest people ever actually win. The first item on the list was to clear the credit line I had opened to cover Richard's fees while the judgment was still pending. Even though the fees were now covered by the court order, the credit line had been real, and I wanted it gone. The second was to buy back a small piece of my parents' original land. A portion of the old property had come back on the market 6 months before the check arrived. I had been watching it from a distance, not quite letting myself want it. I called the realtor the afternoon the check cleared. The third was to hire the person my consulting firm had needed for 3 years, someone to handle the operational work I had been doing myself so I could focus on client relationships and growth. I found the right person within 2 months. The new office was modest: a desk, 2 client chairs, a window onto a quiet street. On the wall behind my desk, I hung a framed print of my mother's letter. Not the original, that was sealed in a fireproof case at home. But every day, sitting down to work, I could read her handwriting. That felt right. Word travels in a small town, not through announcements or social media posts, through the quiet, persistent current of people who know each other's families and watch what happens over time. By the summer, people I had not spoken to in years were stopping me at the grocery store or the post office or the Saturday farmers market to say that they had heard, that they were glad, that they had always thought well of me and my parents. An old neighbor of my parents, a woman named Gloria, who had brought soup when my mother was sick, stopped me outside the hardware store one afternoon. She held my hand in both of hers and did not say very much. She said, "Your mother would have been proud." I thanked her and walked to my car before I let myself tear up, because I had gotten into the habit of not crying in public during those months, and the habit had stuck. Alan and Brenda remained in their rental. I did not hear from them again after the evening Alan came to my door. Vivian stopped calling. That particular silence, the absence of Vivian's voicemails, was one I noticed with real relief. I am not a person who believes suffering is a lesson that gets taught to the right people at the right time. Life is not that tidy. But I do believe that the way you conduct yourself during a hard thing matters, that the methods you use shape who you are after it is over. I had used legal means, honest facts, and patience. I had not lied, not threatened, not manipulated. I had simply refused to let a lie stand unchallenged. That was all. And when it was over, I was still the same person I had been going into it, just more certain of something I had always suspected: that doing things the right way is not the slow path. It is the only path that leads somewhere worth going. I sit here tonight in my own home, 63 years old now, looking out the window at the Virginia fields I thought I had lost forever. The evening light is coming in low and gold across the land. The same light that came across the same fields when I was 10 years old, and my father was building the back porch, and my mother was calling us in for dinner. Some things change completely. Some things carry on. I think about what this year has cost me. The money, obvious, documented, eventually recovered in part. The time, months of hearings and depositions, and late nights with highlighters and spreadsheets. The relationship with my brother, which had been fraying long before Frankfurt and is now something I cannot name precisely. Not quite ended, because he is still alive and still my blood, but changed in a way that does not change back. I think about what it gave me. Not just the settlement and the land and the firm, though those matter, and I do not pretend otherwise. I mean something else. The knowledge that I am capable of standing up for myself through the longest and most exhausting kind of fight, the legal kind, the documented kind, the kind that requires you to be right not just in your heart but on paper, in court, in front of a judge who does not know you and has no reason to take your word for anything. I did not become like them to win. I did not lie or hide or manipulate. I just kept telling the truth, kept saving the evidence, kept showing up, and let the process do what it is designed to do. If you have read this far, you know the whole story. And if someone in your life has looked at your patience and your kindness and decided it means you can be taken from, remember this: kindness is not weakness. Patience is not surrender. And the long game, played with honesty and the right help, is always worth it. Stand up the right way. Stay in it. The truth has a way of landing exactly where it belongs.